If there are no other questions, I would kindly ask our colleague Alisa Pestryakova to talk about the restrictions introduced by the government in the field of intellectual property, and especially in the interaction with the Rospatent. I know that you will also briefly present to ourselves let's say the entering in the market of the medical products, which is quite a hot topic in these days, and finally the options that are that are available for extending the terms of certain actions like payments and so on, which is still an interesting information to know for enterprises. Please, Alisa, go ahead. Thank you.
Thank you, Armando. Sorry for this. И микрофон. Звук сам. Не только микрофон.
Background. Okay.
Some problems because we are in the same room.
Maybe with the headphones.
Oh, I know. Unfortunately, Igor needs to stop his attendance at the seminar, but he'll be back, I'm sure, to make another presentation. I am starting my presentation, which is devoted to COVID-19 regulation and changes in the IP area. For those who don't know or doesn't work with the IP, I should briefly tell that IP is usually known as patent, trademarks, utility models, copyright, and geographical indications, appellations of origin, all this stuff. And in Russia, the main state authority who is doing all the work on IP area is Russian Patent and Trademark Office, which is shortly named Rospatent, and we'll be talking about changes in IP and in interactions with Rospatent. So here we are. As I told, the areas which we cover is the procedure of interactions with the Russian Patent Office and law regulations. About the procedure first, during the period from 16 March till 18th May this year, there were special rules on operation of Rospatent. It was working as an agency and the place was doing their job, but the Rospatent was closed for any visitors. What does it mean? It means that we were not able to file any documents in hand at the correspondence receiving point at the Rospatent. No hearings of the Chamber of Patent and Trademark Disputes were conducted at the office. Only video conferencing format was used and online for any of dispute resolutions. We should say here that, of course, not all the applicants or not all parties can always use this format, online format. So this was used only in the case when all the parties can use it, have technical all technical possibilities and confirm and specifically request for video conferencing format. And as many other companies, state authorities and everyone, almost everyone, all educational and information programs of Rospatent were conducted online as webinars. And this period was not very easy because quite a lot of people use correspondence receiving points to deliver the correspondence, the applications, the requests, answers to any correspondence of the Rosbatan through the office exactly. But this was not the case during the period of closure and the restrictions. What was available at that moment? Electronic services, of course. They are special services provided directly by the Rosbatan on its site or at the state service Gosuslugi, which is quite well known in Russia and provides a whole range of services and interactions with the government, with the state authorities, and also it includes some services in IP area, of course. Russian Post is the second point. Of course, it was available for use. The Russian Post was working, and Rosbatant has always received the documents sent by post and registered upon receipt. So we should always keep in mind the term of delivery, which is not always can be estimated easily when your correspondence will arrive at the office, but still it's a working way of interaction. And the third point, which was new in the time of restrictions and pandemic, and offered by Rosbatant, which is very, very good actually, and used a lot, I'm sure, with electronic mail. They just announced that they will receive all the correspondence as usual provided to the correspondence delivery point at the office through the electronic mail, as if it has been filed on this date to the office in hand. And they, at some point, it was probably the easiest and the only possible way of filing documents, because electronic services request and need the digital electronic signature of the patent attorney or a person, if it's general director and he in any way has the digital electronic signature, he can use all these electronic services. But otherwise, in the situation of pandemic, when you cannot easily get it, the electronic mail was a very good option, replacing offered by the Rosbatant, replacing other options. So what happened next? On the 18th May, Russian Patent Office suspended accepting all the correspondence through the email and opened back correspondence receiving points, but in no-touch mode. What means that you just hand in your documents, your correspondence, put it in the envelope and leave it at the office. Usually when you hand in the office, you straight away receive the notice from the Rosbatant prepared by the employees, saying that and confirming the receipt of the documents. And for example, if it's a case of filing an application, it provides you straight away the number of application. In case of no-touch mode of acceptance of correspondence, you will get it maybe in 2 weeks, because Rosbatant have 5 days for registration of correspondence, incoming correspondence, and then it sends by regular post the notice. Surely the date of application or receipt date of correspondence will be the one when you in fact left the correspondence at the office. But in case of getting confirmation, for example, if you need to provide this as a proof, sometimes this can be not very easy, and the delayed confirmation. But of course, any other electronic services continued working. In fact, they were introduced even before pandemic. It was not the start of using electronic services. And you can use it for filing applications for registration of copyrights, for renewal, and even during this year, also the Rospatent introduced the option for filing applications to the Chamber of Patent and Trademark Disputes, which is good news, because previously it was not available to do through the electronic service. What else has Rospatent changed? It's the examination procedure for patent applications, not for all applications, but for certain applications covering the areas that are essential for treating various diseases, for fighting pandemic, and they put it in 5 groups, in 5 areas of knowledge of potential inventions: antivirus medical products, diagnostics of virus diseases, for example, it can be tests, medical goods and devices, protective equipment, sterilizing agents, sanitizers. Rospatent promised and started, it was their initiative, that they will provide first result of examination within 2 months from the application date. It's very fast. Actually, usually it's a formal examination, only takes 2 months. But in this case, they were doing substantive examination during this same period. The only issue that can be noted here, that some of the documents, earlier documents that can affect patentability of the certain invention cannot be available, published and open during these 2 months, and later on can appear and there will be some questions with patentability. But anyway, it was an attempt to make everything that is useful for fighting the pandemic as soon as possible for the public. In this case, I also need to note that this doesn't need any special request on side of applicants. It was automatically done by the Rospatent. They also made a special section on the site. You can see the link with the same areas covering, which I mentioned already, with the information on all available inventions already made and registered in these areas, so that the inventors can use it and create and invent something new on the basis of it, not looking through the tons and millions of documents just all in one place. And they told that we hope that accommodated knowledge disclosed in patent materials will be useful to Russian inventors creating solutions for fighting viral diseases. Actually, I don't think it can be useful only to Russian inventors, but of course they first of all think of their own citizens. So the next point is amendments to law regulations, and as I mentioned in the beginning, this covers not directly the IP area, some of it, but related, because it's changes to the procedures of carrying out clinical trials and registration of medical goods and medicinal products, so-called and well-known in European Union marketing authorization. This also, of course, is done in Russia, and in the situation when new medicinal products and new medical goods shall be introduced on the market in a very short period of time and is very needed. Russian government decided that there can be some omissions to the standard procedure and introduced two resolutions, number 430, 441, both dated on 3rd April, on special conditions applied to the situation of emergency or threat of emergency and emergency response, which is of course situation of COVID-19 this year. What does these resolutions? It's quite enhanced, and I will touch only the main points that of the documents. So the resolution devoted to changes of regulation in connection to medical goods and services allowed omission of certain mandatory procedures and its regular technical tests, toxicity tests, and clinical trials. Again, this is all applicable only in circumstances of threat, appearance, and emergency response, and to the and should be specifically allowed. I should say that this covered the period till 1st of January 2021, but in November this year, both resolutions, this and the one devoted to medicinal products, their period of validity and applicability has been extended till next year, till 1st of January 2022. So amendments to law regulations in connection to medicinal products, what this covered mainly. This was three main points covered and allowed in the resolution. First, devoted to the medicinal products imported from foreign countries. And it was presumed that medicinal products already got all the relevant approvals in the country of origin, and all the clinical trials, all the tests, and all the needed assessments has been done and checks. So this is applicable for products imported from foreign countries. The requirement for assessment of balance of effectiveness and risks of the medicinal products was considered as not critically essential, and only short report on preclinical trials can be provided for such kind of medicinal products. The full report and full longly trials are not needed. The second point is that laboratory experiments, the obligatory and mandatory laboratory experiments, were replaced, can be replaced with tests according to procedure described in the federal law and circulation of medicinal products. And the third point is connected with the, not exactly with the clinical trials, but more with the interaction with state authorities. All documents can be filed in electronic versions only, which was, I'm sure, very useful during the pandemic, closure of offices, restrictions, and of course this was aimed to shorten the time of review of documents and fast delivery of products to the market, medicinal products. What else? As Armando mentioned, the extension of term for exercising legally significant actions. It sounds not very clear, but I'll surely explain. This is the long name of the resolution, but in fact it's devoted to and allows applicants and right holders of IP rights to to file certain documents, to answer the request, to pay official fees after the deadline, when the deadline already expired. And this was made on purpose to help the applicants and right holders to keep their rights maintained and not to lose the opportunity. What can be extended? It's of course essential. The actions that are listed in paragraph 3 of Article 1246 of the Civil Code. And these are connected with the state registration, for example, examination procedure of applications, answering the requests of Rospatent, or payment of official fees for examination procedure. Second, connected with issuance of patent letters and registration certificates. When the decision on registration of or granting a patent is taken, there is a certain period of time within which the applicant should pay the official fees to confirm his wish to get it, and the certificate or patent letter is issued. If payment is not made, the application considered abandoned, and this is a problem. This law change allowed to keep the rights and to register even after the deadlines. And other actions which meant in the paragraph 3. What does it mean? We can refer to renewal of any rights, for example, renewal of trademark, or yearly maintenance patent fees payment. And all of these actions and deadlines in connection with these actions that expired during 30th March this year till 30th November this year can be extended, which was good news, and it covers quite a long period of the year. In fact, it's all the terms can be extended till 31st December. And the start of the effective starting date of the resolution 22nd of June. So it's mostly because it was the 2 days after the resolution has been adopted, in fact. So if you have anything pending, but not very long time, I'll explain, you still have a chance to keep your right. What are the special conditions for it? What shall we need? It's not automatic as for patents examination procedure of Rospatent. It was their initiative. This is done only against request of the applicant or right holder. So it needs to be filed to the Rospatent. And it's essential that this special request shall be filed within 1 month from the date of expiry of the term, or within 1 month from the effective date of resolution, whichever is later. I'll explain how it's supposed to work. For example, you have maintenance, patent maintenance fee deadline payment deadline 15th of November. If you file today the request for extension of this deadline, you'll have the time till 31st of December to pay this maintenance fee, and your patent will not be invalidated. Of course, the patent can be patent protection can be resumed, which is not the case for trademarks, and it is very useful, I think, in case for economic reasons or reasons of any kind of restrictions, right holders were not able to pay the fees or provide certain information as an answer to requests of the Rospatent. And in case the deadline was till 15th November or later, it's still the chance to keep your right or do the right action till the end of the year, which is good. So I've covered the main points, and here is the last slide asking what will be in the future. And we see that the Russian Patent Office introduced previously their electronic services, and they were very much using it and promoting use of it for all the applicants and all the right holders. Their own and both available at State Service Gosuslugi. And I think this trend is developing because the Rospatent is considered to be a highly digitalized state agency, and they would like to continue this. This year, it's not connected with COVID, but starting from next year, 1st January of 2021, electronic documents will be introduced for all the IP rights, registered IP rights, patent letters, trademark certificates, utility model certificate, design certificates, any documents will be issued as electronic documents. At the request of the holder, they can be issued on paper, but the main document will be electronic. I know that this is already in place in the European Union, but it's good news and developing in Russia. And I think it's very convenient because it's where we all, I think, tend to move to digitalizing electronic services and all this stuff, and use, for example, the option introduced this year also for filing requests and applications to Chamber for Trademark and Patent Disputes was very good and essential. And I think all these options developed, like online video conferencing, hearings, filing, will be highly used, also minding the big area of territory of our country. Not everyone can go to the Rospatent directly to file the documents, and will be using a lot of this stuff, I'm sure. So this is the end. If you have any questions, I'll be happy to answer it.
Thank you, Alisa, for your general overview of the legislation, of the changes, the measures which have been adopted in the area of intellectual property. It looks like there are no major changes in the area, apart from trying to face the major difficulties due to the fact that maybe some terms were missed or people were busy in some other activities and could not give enough attention to the protection of their intellectual property rights. No major changes apart from, let's say, the area of medical and pharmaceutical products. So, here comes my question, which is not strictly connected to IP, but it's generally related, maybe connected to the regulatory aspects. We know that there is a race between the countries in order to approve their vaccine in each country, and of course Russian have come first in this race. At least this is something which is on the news in our Western countries. This is also a question which comes from my friends and colleagues here in Italy. Can we import the Russian vaccine in Italy, and what are the restrictions?
Actually, concerning the vaccine, these emissions provided by the regulations was also applicable to the vaccines, of course. So that is why Russia was able to provided and enter the market and start doing vaccination earlier than the other countries, especially to these regulations. I'm sure. And to answer your question, 2 weeks ago there was information that it's not available at all. Now the most recent information I saw on vaccination is that it's available and started doing now. It's not available for importing, in person, or in small lots. There will be, I'm sure, and is discussed, exporting vaccine to certain countries on the government level. But as for the way of just buying and delivering some smaller lots, it's not available right now because they even haven't decided on the price of it yet. They're still calculating. They are started vaccination, providing it to the hospitals, clinics, but not available for purchase in clinics or in pharmacies yet. If it will be available for purchase on an individual basis, I guess another point will be not easy and should be noted, not connected to IP area, of course. It's the special requirements for delivery and for keeping the vaccine temperature, for example, or something like this. So I know that this is sensitive to this kind of conditions and requirements, and whether it's possible to keep all these conditions and to keep the vaccine alive. I mean, delivering in case buying here and trying to deliver abroad. This also should be noted and kept in mind. And again, this will be an issue with the delivery service and customs, whether there will be allowed and officially or officially prohibited for exporting. I mean, if there is an issue, we can keep an eye and try to get some information, at least basic information, where there are some options or still not at this level. At least we will keep an eye.
Thank you, Alisa, for your, let's say, comprehensive reply.